Welcome, um, Bhumika Billa. I'm not sure I'm pronouncing your name right, but I'm inviting you to take the floor, introduce yourself briefly, and give us the core of your paper in 15 minutes.
All right, thank you so much. My name is Bhumika, and I'm a PhD student at the Faculty of Law at University of Cambridge. And thank you so much to everyone who's attending, both in person and online. The title of my paper is Law as Code, and it's sort of a starting point of a theoretical framework, which I call the information theory of law. And I'm lucky to be following Professor Virginia because it sort of complements her work in the sense that as algorithms lock in, create power lock-ins and reinforce existing biases and inequalities, my paper is sort of aimed at laying the groundwork of how law does the same or how legal systems do the same thing. In my presentation, I'll briefly talk about the title, which is Law as Code, and what do I really mean when I say law codes reality. I'll follow that up with the objectives of the paper, followed by the two external frames of reference, which I use to build my theoretical framework. And then I'll be finally discussing the shortcomings or shortfalls of those frames, followed by the contribution. Now, just to ground these abstract theoretical ideas, not just in reality, but also in the present moment, what do I mean when I say law codes everything around us? So if we imagine legal system to have these sort of closed boundaries of legal language, then it translates everything outside of those boundaries into sort of legal language or juridical language that the system can then internally understand. So the computer that I'm using to present today is translated juridically by law or coded, so to speak, by the legal system as movable property. These ideas are coded as intellectual property, and I am coded as a legal person and who has sort of these legal identities based on gender, nationality, so on. So this is the broad sort of framework of, this is the idea of why law codes everything around its boundaries. But why should we really care about, or why should we study how law is interacting with the society? I base sort of the motivation or the critical element of this research in Katharina Bister's work. And she has basically argued that the way law has coded assets and capital over decades, that has, or historically, that has sort of deepened the inequality, wealth inequalities, and reinforced power gaps within the system. And which is why we should, which is why it is sort of important to look not just at the fact, or not just acknowledge the fact that law codes reality in these exclusive ways, which give certain experts more control over these processes over the other, but also focus on how that happens, how that process happens. And this is where I sort of I aim to fill in the literature gap by focusing on how law codes our social reality into rules, regulations, legal terms that then sort of create rights and obligations. So in the context of all of this, the objective of my paper is I'm going to use a couple of theories, two of the many possible theories actually of information and communication from two different disciplines, to study how legal systems communicate both internally and externally. And then my present paper, in the process of trying to achieve that aim, I also hope to indicate the limits of limits of computability of law, but also this approach to thinking about law, this computational approach, and the limits of sort of this entire field of booming field of computational law. Now coming to my frames of reference, I use two theories. One is Shannon's information theory from computer science, and the other is Luhmann's systems theory from sociology. And we can always come later in the discussion to my choice of these theories, but to briefly explain why I chose Shannon. Shannon's information theory is sort of the most basic, simplistic theory of communication. It explains how each and every act of communication takes place and how a message is digitally transferred from one source to another. So I use Shannon to explain how juridical or judicial communication happens internally, how a legal system communicates internally. And I use Luhmann's systems theory to then expand that to outside the boundaries of the system and how this communication takes place outside the system as well. Now, to briefly explain Shannon, Shannon's objective of the theory was to cut down on any possible errors, risks, and noise in order to make a transmission of a message from any source to any destination as quick and efficient as possible. And in this process, the proposed model was that in order to transfer a message from one point to another, it's best if it is coded. The message is first coded by an additional transmitter in the process, who then sort of passes it on to the channel, which wets out the noise. And once the receiver receives the coded message, it then sort of decodes the message to retrieve the original information and finally pass it on to the destination. Now, that's, again, a very simplistic gist of the theory. And the two key things to note here is, one, that the message to be transferred, be it a text or a video or an audio, no matter the format of the message, it is not going to affect the transmission of it because it is coded by the transmitter and receiver. And the second key point to note is that the purpose, again, of this encoding and decoding is to minimize sort of the noise and the redundant information present within the transmission and make the transmission and the communication as quick and efficient as possible. Now, if I was to sort of compare how code and messages work in Shannon's system with law, then I would argue that law contains different aspects of our social realities in the same way that code contains the message, because message is translated into codes and then social realities translated into the legal system using legal language. And again, like borrowing this and mapping it onto the elements of Shannon's communication model, if we were to think about where a communication is triggered within a legal system, it starts from a coordination problem amongst the legal subjects. That coordination problem can be a conflict between a landlord and a tenant, or an accident, or even a protest demanding a legislation or demanding striking down of a law. It can be any sort of a coordination problem, and that sort of triggers a single cycle of communication within the legal system, which then is translated into legal language with the help of legislators, parliamentarians, judges, and then it is transferred to the courts. The law is transferred to the courts, where it is again decoded with the help of legal experts who are judges, lawyers, legal interns, clerks, and all the court staff. And all of them contribute to this decoding process, where it is then applied back to the facts of the case and finally reaches the legal subjects in the form of remedy or in the form of relief or so on. So that's the sort of communication that happens in a judicial or a legal system. And in this process, again, there are three key observations to be made. The first is, if we closely look at the transmitter and receivers, they both can be sort of bracketed together in a group of legal experts. So anybody who knows the legal language or who has some sort of say in what information gets vetted out of the system and what gets decoded and how it gets decoded, in all of that process, these can be clubbed together into a category of masters of code. This is to quote Pister. And these set of experts have more say over how the information is transmitted in the system than the rest. Another key observation, the second key observation, is the information source and the destination ultimately loops back to the same thing, which is the legal subject. So unlike and my second and the third observations would depart a little from the Shannon's model, because Shannon's model was to explain and optimize communication in a linear digital system. Whereas if we look at the way legal communication systems work, then the information source and the destination are the same, which makes the system non-linear or cyclic in some ways. The third key observation is the noise source. Again, this departs a little from the Shannon's model, because while in digital communication, Shannon tried to sort of wet out the noise, I would again argue that noise becomes relevant in legal systems, and I would come to that in a bit. Noise becomes relevant in the legal systems because it makes the systems more adaptive, and it is rather a desirable element in the entire legal communication process. So while Shannon's frame helps us to conceptualize how legal systems are communicating internally, I borrow from Luhmann's systems theory to then expand that to outside the boundaries of the legal system. And that's where the element of noise also comes in. How does the system adapt or respond to the environment outside of it? And Luhmann's theory helps conceptualize any system that has boundaries outside of it, which separates it from the environment, from the external environment. In the case of law, that being legal language, legal statutes. Now, a system that is self-autopoietic would basically be equipped to self-correct, self-refer, and self-align itself with its original motive. And that it can do because of two things. Because of its operational closure, it is able to separate itself from the environment and sort of self-sustain and self-correct. And because of its cognitive openness, it can think and respond to the changes happening outside the boundaries. And if we put that in context of law, again, law is closed because of the legal language and because of the control that the transmitters and receivers and all these legal experts have over the information flow in the system. But it's also cognitively open because it allows the input of noise from the outside in order to adapt to the changing environment. And that's how law becomes flexible. Now, I go a step further beyond internal communication and adaptation to the changing environment to argue that the legal system doesn't only adapt to its external environment, but also shapes it. And that's where that makes law not just responsive or reflective of the society, but also a tool that shapes what it is encoding and what it is reflecting. And to go back to our original example, so for instance, I am a legal person who sees myself as female, as Indian, because the law has sort of shaped these ideas. It has told me that these aspects of identities are identified or recognized or like legally valid. And that is how law has sort of in some ways even shaped the way I see myself. So it does not only translate my identity, but also shapes it. And that is what makes law reflexive in some ways. So to kind of sum up the three claims arising from Shannon, Luhmann, and the extension of Luhmann, the first claim being law is exclusive because the people who know the code are more powerful than the rest. And that again loops back to what Pfister was saying, where the masters of the code get to design the code, and the code excludes those who do not necessarily understand it. And that's what makes the code a little less transparent. The second claim being noise, which again, this is a hypothetical claim and it remains to be tested because it is sort of based on this patchwork of literature, on vagueness, on computability, and different works by different authors. But it yet needs to be plugged into the noise element of, if we were to think in Shannonian terms, that what makes the legal system adaptive is the noise that is inputting into the system. And the third claim being law is reflexive, and which is largely based on Jennifer Cobb's work, and which sort of extends what I have been able to reach at using the apparatus that Shannon and Luhmann offer. And what makes law reflexive is its ability to shape what it is encoding. And to wrap up what the contribution of this paper is, Shannon's theory offers the groundwork for the exclusivity claim in the sense that it lends the apparatus to understand how legal communication takes place internally within the system. even though there are points of departures, which again I'll come to in a short while. Even though that happens, even despite the shortcomings, there's a solid ground to build an agent-centric critique of the legal system, and why, like as Professor Virginia was also arguing, why there's bias in the system and how does it get locked in because of the transmitters and receivers who vet out the information in that way. And this again builds and extends Pister's work as well. And the contribution in terms of Luhmann's theory lends to an explanation of why the entirety of law is not and cannot be computable, because it is the text-driven nature of law, and to use Professor Hildebrand's terms, it is the plasticity embedded in the text-driven language of law that makes it adaptable to the outside environment, and that's how it responds and adapts to the outside environment. The shortfalls, however, are that even though I can explain the adaptability and exclusivity of the legal system and the internal communication, I'm unable to use these frames to sort of explain how the system externally communicates. And that's where I think that requires more work to be done in terms of what exactly makes the system reflexive in some ways. And what this also reveals is that there might be limitations to even computational approach to thinking about law generally, because if we are borrowing from these theories, and if like no analogies are perfect, and there will always be limits because of such a complex and plastic and dynamic nature of law, there will always be shortcomings to computational approach to sort of thinking about and problematizing law. And that sort of gives us the impetus to think broadly about where the field is going and whether there are, like, what are the boundaries of the field itself. And and I would say that the paper is a major contribution in terms of the starting point of beginning to model juridical communication in a different way, which can then build and lead to a more broad, radical, systemic critique of law, which then we can loop back to the agent-based critique. And then again, there's a lot more work to be done there. So thank you so much.
Michael, the floor is yours.
Yeah, a very interesting paper, and I enjoyed reading it a lot. I think it's the initial framing of the paper is an interesting one because it takes a theory that, as you acknowledge in the paper, the proponents of the theory say, don't use this for other things, and you're using it, I think, to test and to probe, like, where you find tensions in this, and those tensions can be found in a variety of ways. You might have gone about other methods to discover those tensions, but it's a useful probing tool, and I find that's quite an interesting methodology when you try and apply that and not sort of sell it as the way to explain everything. I think it's useful, and we all need to have our tools to find tensions when we work between law and technology. We work in different ways to find where those exist. A lot of the work that I do, I usually describe as characterizing sort of tensions and exploring them and opening them, and there's different social and technical methods to discovering them. So I wanted to reflect and perhaps extend some of the tensions that came out from your application of this to the law, and maybe problematize a few more areas to add to the observations that you made in the paper. I do that with the disclaimer that despite almost everyone else in my faculty being of this persuasion, I'm not a legal philosopher. I'm not particularly well versed in jurisprudence and similar scholarship, and I feel that a lot of the things that I point out will have many interesting names and chapters to them in the classic volumes of jurisprudence and similar. So apologies for not gifting you with so much intertextuality. You'll have to fill in the gaps yourselves for those who are more knowledgeable. So one part from communications theory in particular, this famous phrase, the medium is the message, and understanding the kind of connection between the medium and the message here in law. Well, one interesting thing about law is that the message also often encodes the medium and the channel. We have laws that say, well, who can bring a case? In which forum can you bring this case? What kind of method of decoding is used? What interpretive method for this law has to be used by judges or other ombudspeople, adjudicators, or similar? In the UK, we have, and I'm sure you know, lots of discussion around the Human Rights Act now, and the role of the ECHR, and the role of interpreting law in relation to ECHR law. And that is a restriction on the way interpretation can happen, and proposals to have regard or not have regard to certain characteristics in these decisions are part of the message itself. So there's this interplay. We see this a lot also in intelligence law, where you can end up in quite circular situations. So the message itself can lock you into a situation where you can never really resolve or build or decode a message because you can't ever get standing, for example, to bring a case. In the US case Amnesty and Clapper, for example, that is a notorious situation, and we've seen similar things in the UK with the Investigatory Powers Tribunal. Common law systems, which I'm definitely most familiar with, are also interesting in this theory because I don't see there's a clear distinction, at least in the case of higher courts, between encoding and decoding. When you decode a message as a judge, this is also a speech act, and it's a political act in many cases that you are choosing to encode something else that may bind future judges. And so I feel that could be built on more in your paper, those connections, because that's a simultaneous action. And what does it mean to simultaneously decode and encode? And Murray treated us with a discussion of some of those issues around speech act theory this morning. Your points as well about the interaction with the broader environment, I think could be expanded even further. It's not clear to me that a communication theory of law fully considers all the intermediaries involved in communicating law to a layperson or having it shape an environment. Individuals do not go and read statutes directly. They don't go and read those documents. There are a range of intermediaries. In the UK, you have charities like Citizens Advice. You have similar organizations around the world. You have websites and commentators and newspapers, and some people have quite crazy ideas of what they think is in the Magna Carta and what they think their rights are that are quite wild in the UK, and they're often on the streets around Westminster. So you've got these folk theories of rights, and I think it's interesting to think where they came from. And these are cases where communication theory maybe is more apt because it relates not to the application of law, but people's understanding of what these are. And maybe that's a very interesting direction about these folk understandings of law and what they mean, also for people's behavior, because we assume that people are supposed to follow the law, and we assume that they would know the law in order to do that, at least to some extent, or they would know where to find out about it. And we also know from much literature that's not always the case, and we have growing legal obligations all the time that can be complicated and with confusing exemptions that are part and parcel of the proportionality of these instruments. I'm always interested in power in the application of the law. And sometimes the destination, as you describe it in the application of Shannon's theory here, the destination being legal subjects, particularly maybe large defendants or large plaintiffs, say a large technology company, they often choose the channel. They are very well known to engage in forum shopping using a variety of means. In Belgium, for example, Facebook is always trying to choose the correct judges it wants to take cases in front of and saying, oh no, we've got this judge or we've got that judge, or we're trying to move the cases around. And so these are very tactical situations. So there's an additional amount of reflexivity perhaps or interconnectedness around this. They've also influenced these fora through other means that are outside of that structure. And of course we see that for example, in the discussion of legal interpretive methods in the United States, just how much you can have concepts about how you might want to interpret the law can be used and weaponized to get certain outcomes that you might want. And that exists more or less in all types of jurisdictions in all sorts of forms. Maybe also drawing on a metaphor from kind of communications world, we might think about who in this process has the power to jam a signal. Signal jamming, where you have a little device, often illegal to use, you can broadcast it out and people can no longer talk to each other or share wireless communications. This would have the effect, if it existed, of preventing messages in the law from ever being decoded. And what might that look like? Where might we find that? Well, we find situations where organizations compromise regulators they deluge organizations with more information they can deal with. They make situations seem highly politicized or insurmountable or highly technical or difficult or value-laden, or we could get to discussing how that's happened in AI ethics, for example, or in areas like online tracking. They conflict lawyers in small jurisdictions, hiring lots of them so that no significantly high-powered lawyers will take the case on another side. They put in alternative dispute resolution mechanisms in quite aggressive contracts and encourage people to waive certain rights away, to move for them and to prevent, in this case again, decoding ever occurring, because decoding is encoding in many systems, and encoding can be quite dangerous because it is a speech act. If you get a judge to say something you don't want, it's a lot more harmful than having that decision made in an alternative dispute resolution area or through a settlement or something like this. And so we can see that there, and I think these approaches to signal jamming may be quite interesting as a direction. Very lastly, there is an important role for silence, as Vrije told us a moment ago. And silence is effectively when you might not want to have any kind of law encoded or decoded. It's maybe a bit different from signal jamming. I just thought about that actually when I was in the coffee break. In the UK, for example, we don't really regulate directly the appearance of child sexual abuse imagery on the internet in terms of which websites to block. It is done through a voluntary system involving a charity called the Internet Watch Foundation and ISPs, Internet Service Providers. And the Internet Watch Foundation passes on a block list to these Internet Service Providers who implement these blocks. These are both private actors. And the government sort of sits there and says, nice thing to do, sounds all good, we're not going to regulate. The result of this is if your website is blocked accidentally, you don't have anything on the website and so on, you don't really have anyone to appeal to, because these private actors don't have a free expression obligation placed on them by human rights law, which they would do if it was a state making that block list. So there is a silence going on there, an unwillingness to do that, and it results in no real law at all. Maybe it is soft law, or soft rules, different kinds of rules, but it is a silence in terms of the law, but that silence is consequential. So those are the points I had to raise, and I hope we get some really fascinating questions as well. Thank you very much for your paper.
Thank you very much. Of course, we're tight on time because we started late, etc., etc. I nevertheless think it's important that you have a chance to respond to Michael first.
Yeah, thank you so much. These are really helpful comments, especially the one about signal jamming. And I think once I begin to sort of bridge the more agent-centric and the system-centric critiques of law using these theories, I will definitely end up getting to the more sort of critical aspects of law that you've been talking about, how it is used as a weapon, how the more powerful legal subjects use forum shopping, and how it's how law is basically gradually becoming a tool to reinforce the power gaps that already exist. And your point about silence was also very relevant, which again, I've been trying to sort of incorporate in my theory in terms of how vagueness in law makes it more adaptable. But it's the example that you gave was very thought-provoking in the sense that so far I have only thought about vagueness as a desirable trait in law, in the sense that to give a very brief example, when the government, or not the government, when the judiciary or the legislators refuse to sort of define gender as binary in their legislations, that has sort of enabled judicial interpretation to move along with the philosophical debates on gender outside of the legal boundaries. So in that sense, I've only been looking at vagueness or silence if I were to sort of equate those two in some ways, in a positive sense. And the example that you gave is quite relevant and very thought-provoking in ways which, I'm yet to think about. That's a lot of food for thought. So thank you so much. I'll definitely work on those.
Lawrence? Yes. Lawrence, please.
Hello. Hello. Thanks, Bhumika. I really enjoyed this paper, as I've told you before. I think going in the direction of Shannon for law is extremely interesting. My reading of your paper is that it's quite a metaphorical application of Shannon. And I wondered, this is just a question, I'm not suggesting you do this, but I wondered if you'd considered applying Shannon at a level kind of closer to his original theory. So in terms of the actual nuts and bolts of the transmission of information. Because it seems to me that, given that we're talking about computational law, the representations of legal concepts, of legal information, of the legal subject, which you referred to in the presentation, those representations ultimately become a form of information when you apply Shannon. And when we think about the infrastructures through which they interact with one another, through which we see evidence of them, they are ultimately Shannon-style representations. So what I wondered is whether you thought there was scope for an analysis of how those legal concepts, and I think particular legal subject is an interesting one, are affected by that representation. So the notion of a contract, the notion of a legal norm, the notion of a legal subject, when represented in a binary form, for example, does that do anything to the nature of that institutional fact? Maybe it does, maybe it doesn't. I just wondered if you had any thoughts on that. And I realize it's what I'm asking is at perhaps a level closer to the metal, as it were, than you're applying in the paper. But it just struck me as a direction that perhaps the application of Shannon could go in, and it could potentially expose some very interesting concerns, I think. Thank you.
Yes, you can immediately answer.
Thank
please.
you. Yeah. Thank you so much, Lawrence, for your kind words and also for the question. So just as a disclaimer, because I did feel a bit inequipped to deal with the technicalities of Shannon's theory, because I didn't know if I didn't want to talk about something that I haven't really wrapped my head around as well, because of lack of training, both methodological and content wise. But what you mentioned is very relevant, especially in terms of how legal encoding makes things into binaries, and that's what like Luhmann has been talking about as well. Like everything is either illegal or non-illegal, and I think that could again go back to the point I was making about how law shapes our social realities in terms of different concepts in contract law, for instance, or even gender, which is something that I've also been thinking about in context of my theory so far, and how like legal encoding of gender as binary has affected the way people have seen gender or understood gender for the last many years. I will definitely look more into the technicalities of Shannon. And also I'm very tempted to look at other information theories as well in computer science, which I have been sort of feedbacked to look at in terms of how they could be more equipped to deal with systems as complex as law. So there's definitely a lot more work to be done. So I'm a little conflicted about whether I want to go deeper into Shannon. And if you think there is scope, which you mentioned, I'd be very happy to continue the conversation like after the conference as well.
Thank you. Giovanni?
Thank you for your very interesting talk. And well, actually, you're presenting theory of Shannon as a theory of information, but indeed there are also alternatives of theory of information in computer science. And actually, Kolmogorov theory is considered to be even more general than Shannon's theory, because Shannon's is just applied for communication again. So we don't care about the message; we just care about the communication channel. We could like send any symbol, it's the same as far as the frequency is maintained. So only the frequentist aspect is what makes sense in terms of communication. While for Kolmogorov it's just the opposite. So everything is in the object, and we expect the frequency will be a consequence of the type of object that you have. But what is interesting into taking another perspective is that there is compositionality that is given as given with Kolmogorov theory, while it's not with Shannon's theory. So in cognitive terms, it makes much more sense to utilize that theory of information rather than Shannon. And I have a similar a similar underlying motivation to push you a little bit farther than the references that you took. It's that both Shannon and Luhmann, they take a kind of anti-human view over social system. Allow me this strong term. Because again, the communication is not the message. I don't care who is producing it. It's just like a symbol that could be whatever symbol. And so the is meaning it's given by the other symbol that are sent by the source. And that's the same with respect to Luhmann, because he explicitly, there are several passages in which he removes all kind of teleonomy or no, teleology of all levels. So not only historical progression, but also individual one. So there is no driver that is driving the system. It's just for self-reproduction, even at a communication level. So that's even from the people are disappearing in the story. So that's our only communication that is self-sustaining itself. But then I was very fascinating also during my PhD. I started by reading a lot of Luhmann, but at a certain point I was missing a lot of aspects. Because the underlying reason why we engage into communication, that's because there are other things that are below that level only. And I fear that if you're staying only up, we are losing. It's kind of, again, we are looking at this system as it's not made by humans, as humans are not part of the story. It could be any type of artificial system, and we could apply the same type of concepts. So I don't know, what are your thoughts about, you already said a little bit of limitation. I've already seen pinpointing also to other limitations, but perhaps you have already some thoughts on that. Thanks.
You can respond to that one, and then I still have one question from Frank Pasquale on the chat. And then we go into the coffee break.
Okay. Thank you so much for your question. It's indeed very interesting and insightful. I have actually been thinking about that as well. Like both Luhmann and Shannon are obsessed with systems, and we can't really separate the systems from their agents, and which is where I bring in sort of the works of Katharina Pister and Jennifer Kobe, and how the agents in these systems control and vet the information and control the flow of the information, control these encoding and decoding processes, and how then, because of the agents, the systems shift power in ways, it depends on who these agents are and the identities of these agents, for instance. So in that aspect, of course, there's limit to what the scope of the paper allows me to do, but to exactly do that, like to bring in the humans back into the picture, I'm actually making my PhD project now empirical, and I'm interviewing these sort of agents, so to speak, to ask them how, in their view, the law has shaped them, and what their role in the system is, in their opinion. And all of this empirical work is to basically do exactly what you mentioned, to bridge the sort of agent-focused study of the legal system with sort of the systemic approach which my theoretical framework presents, which again I very much acknowledge has a lot of shortcomings and does not have the key element of humans yet in the theory itself. And the claim of, again, reflexivity and adaptability and exclusivity, these three claims are yet to be tested through that empirical work. So and thank you so much for your suggestion to look at the additional theory of computer science as well. I'll definitely look it up. Thank you so much.
Okay, I'm going to read to you Frank Pasquale's question. He's saying this is a very illuminating project and presentation, and he was wondering if you could address, given that most persons understand natural language and far fewer can program or understand computational language, is text-driven law a comparatively less exclusive form of coding regulations and commitments than computer code? And he's asking this question to follow up on your excellent points on Pistor and Luhmann. So the more critical perspective, how does that relate here? Isn't looking at natural language the more obvious protection? But now I'm interpreting, Franke, that's always dangerous.
Well, thank you so much for your encouragement and for the question as well. I have actually, this is a very sort of obvious and important, rather important link between the descriptive and the critical elements of my project. And in my contribution slides and in the conclusion, I did mention that my application of Shannon and Lubin show the limits or indicates the limits of computability of law in some ways because of the text-driven nature of law. And this exactly hits the nail on its head, because if we move from text-driven to sort of more code-driven and data-driven legal systems, then what we are essentially doing is shifting power from existing lawyers who have control over the system and who make the legal system exclusive. We are just shifting power from those to then computer scientists who know and understand the coding language, and that is going to make the system even more inaccessible in some ways, and again, like feed into the existing power gaps where between individuals, big tech, and all of those things. So it's a very sort of good nudge into bridging my descriptive and critical elements of the project. So thank you so much for the question as well.
Thank you for answering all these, addressing to all these very challenging questions. Thank you for the presentation of the paper, Thank you, Michael Veale, for sharing your reply with us. And nothing is holding us back now from coffee. Please.
Thank you.